Have you or a loved one been arrested for a felony crime in Seattle, Lynnwood, or anywhere in Washington state? If so, it's a very confusing time. My name is Lance Fryrear. I'm a defense attorney located in Lynnwood, Washington, and this is a video about, in general, how a felony arrest works in Washington state and what you need to know to deal with this very difficult time. So, someone gets arrested for a felony, that's a very serious offense. It could be an assault two or a major crime. It could be a sex crime. It could be a high level of theft. And there's many mistakes that the people that get arrested for felonies or their loved ones make, assumptions they make that are incorrect, that can really be difficult and difficult on everybody involved. And so the first thing you need to know is a police officer in Washington state can only arrest for investigation of a felony. They can't actually charge the person they arrest with a crime. That has to be done by the prosecutor. And that's why it's confusing. I mean, I'm arrested and I'm not charged. Yes, that's true. And so, since felonies are major crimes, usually an officer arrests someone and puts them in jail. And if you're in jail, you must think I'm going to have a full charge. Well, that's not so. So the court rules in Washington state say that a judge has to review something called a probable cause statement, a statement that an officer wrote about why they arrested the defendant. And the judge needs to review that typically within 2 court days and then either set a bail or release the defendant. And felonies are serious, so they'll usually set a bail. What is a bail? A bail is an amount of money or a bond from a bonding company, which you can pay, that amount of money or that bond needs to be posted with the jail to secure the release of the defendant from jail. And the theory is that if there's money posted to secure the defendant's release, the defendant will obey the law because they don't want to lose the money if they disobey the law while the case is going on. And so the court needs to set a bail or release the defendant within 2 court days. And then the real interesting thing is that the court rules say within 3 court days, if the prosecutor has not filed an actual criminal complaint in the court, then all conditions against the defendant, including the bond or anything like a no contact order, it has to disappear. So then the probable cause arrest is dismissed. And so that's a big confusing thing because many people get out of the jail either by posting bond or being released, and then they hear their case was dismissed, and they think it's all over. And it's not. It is not all over. It just means that the prosecutor made a decision to not rush file, that's what I call it, an actual charge within the 3 court days. And so let's say, okay, I've been released, the case is dismissed, I never think about it again. And then 3 months or 6 months later, or even a year later, you get a felony charge in the mail, or even worse, you get arrested because you didn't know the prosecutor reviewed the case and filed a felony. Because in most cases, the prosecutor has 3 years or longer to make that decision. So if you get released from the jail and you hear your case is dismissed, that doesn't mean it's over. So please contact an attorney. The other thing about a felony charge, when the defendant is waiting in jail for that first day or that second day and a bail gets set, it's usually a good idea from our point of view. We'll tell our clients to go ahead and bail that person out of jail. Because while the person is in jail, the prosecutor has an incentive to hurry up and file a charge because prosecutors are there to protect the public. And in their mind, the public is protected if a charge is filed against a defendant, and therefore the conditions can be maintained like the bail. Because remember, if they don't file a charge on 3 court dates, the conditions have to go away and the defendant's released. So if you have the option, typically speaking, we recommend to our clients, let's try to get the defendant out of jail. There's exceptions to that. If the defendant runs off, you lose your bail money. If the defendant's in a really bad spot emotionally, they might go commit another crime or harm themselves or others. That's another thing to consider. So always talk to an attorney, but there is a decision to be made. So those are a couple of the practice pointers about what's confusing about a felony arrest. This isn't a video about everything, just that first arrest part and what you do now. So if you have a loved one in jail or you've been recently released on a felony and you need some help, feel free to give my office a call. Again, I'm Lance Fryrear, the owner of the law offices of Lance Fryrear. We've been defending people charged all throughout Washington state for more than 20 years. We'll set you an appointment. We'll talk to you on the phone. We'll do whatever we can to help. We'll be there for you. Thank you.